I get asked a lot, what's the worst thing you've seen a school do in a Title IX case? How bad can things really get? And the answer, unfortunately, is really, really bad. And I'll give you two examples. So the first was at a private school where the investigator conducted 3 interviews with the complainant. But in the second interview, the complainant completely changed her story and contradicted herself in the most fundamental ways you can imagine. And the investigator, who saw himself in a different role, I think, decided to just bury that second interview. And so we got a report that contained the first interview and the third interview, but not the second. And it was only from reading the third interview very, very closely that we realized, wait a second, some of the statements here are responding to things that appear nowhere in the first interview or anywhere else in the materials. There must have been some other conversation between the investigator and the complainant than what we have in this record. And it was only after threatening to sue the school that the school finally made the investigator produce this hidden second interview, which completely exonerated our client and ended up with him being found not responsible. The other example involves a school lawyer at a public school who became extremely personally invested in a case because some of the evidentiary decisions the school made about what kinds of information we could see were decisions that we had to take to court and were ultimately reversed. And so this lawyer's decisions looked really bad, and she became very invested in the outcome of this case. And we learned later that the adjudicator, after the hearing, was primed to find our client innocent. But that what happened is the school's lawyer lobbied the adjudicator for 4 days, ultimately convincing the adjudicator to change her mind and publish a decision finding our guy guilty. And the only reason we discovered what had happened is because after reading the decision letter closely, we could tell from some of the language that was being used and even some of the arguments being made in it that they seemed to really parallel language and arguments that the lawyer had made in court. So we literally hired a computer scientist who developed a program that he used to unmask J.K. Rowling as the pseudonymous author of the Robert Galbraith novels. We asked him to feed the decision letter and the lawyer's written papers in court into his program, and he determined with more than 99% confidence that the author of the school decision letter was the same person that had authored the school's legal papers. And based on that, we went back to the judge, and the judge then allowed us to peer back and to learn about the lawyer's role behind the scene in lobbying the adjudicator for those 4 days to change the decision. That client then also was ultimately found innocent by his school. Now, that doesn't mean that everyone at either of those schools was doing things wrong, but I think what it shows you is that it only takes one bad actor at any school to completely ruin your chance to fairly defend yourself.